This is Democracy,
a podcast that explores the interracial, intergenerational, and intersectional
unheard voices living in the world's
most influential democracy.
Welcome to our new episode of This is Democracy. Today we're going to discuss the Supreme Court, which we've discussed in prior episodes, but today we're going to focus on the confirmation process for justices on the Supreme Court for their lifetime appointments. We're going to talk about how this process is supposed to work, how it has worked in the past, and why the current controversy over the nomination by President Trump of Amy Coney Barrett to replace Justice Ruth Bader Ginsburg, why that controversy is so serious today, and what the stakes are, not just for the future of American politics, but for the future of the Supreme Court, really. We have with us one of the foremost scholars of this topic, a good friend who's been with us before, Steve Vladeck. Thank you for joining us today, Steve.
Thanks for having me back, Jeremy. It's a pleasure.
Steve Vladeck is the Charles Alan Wright Chair in federal courts at the UT Law School. He is one of the foremost scholars of the Supreme Court. He's actually the CNN analyst for that topic, among many others, and he writes extensively. I know many of you have read his op-eds in the New York Times, Washington Post, and elsewhere. He has a very active Twitter feed
I'm sorry. I'm apologizing for my Twitter feed.
Oh, you're apologizing for your Twitter feed? You shouldn't apologize for that.
Yeah.
There's some Twitter feeds are more valuable than others, right, Steve?
Well said.
He's also the co-host with another friend and colleague, Professor Bobby Chesney of the National Security Law podcast through the Strauss Center here at UT. This is one of the most important podcasts on understanding national security. I know many of our listeners listen to that podcast. He's also part of the Lawfare blog. So we have a lot to talk to Steve about today. But before we get to that, we have, of course, Zachary Suri's scene-setting poem. What is your poem titled today, Zachary?
By Allergy and Allegory.
Let's hear it.
There is a ghost land somewhere near of spirits of the earth and aging oxygenated dirt, and there is hope and there is hate, but no one ever shows up late. They are driven purely by allergy and allegory to lonely far-off woods, and they circle round the fire pits with their woulda, coulda, shoulds. I'm allergic to fear and allergic to rage. It makes me cry and it makes me age, for I can feel the poop deck fall right back and the ship open up to the breeze. And what do you do when the ship is sinking and the mice only care about cheese? I can see into the distance where justice can be served, but I have very little hope indeed that I'll ever see this world. What's it like falling backwards, sinking with the ship? What's it like returning to the years of whip and zip? What's it like at your station with your semi-automatic gun, waiting for tax evasion and religious list salvation? What's it like? Does it feel comforting to be armed while the world ends? Are you safer as the ship goes down because you can carry your gun to town? God created money so some would have to starve, and God created justice for the wealthy ones to carve. And God created people so someone could be killed, and God created forests for the factories to mill. Still, you can grab the pickings as the sinking ships go under, and we will save some hope indeed, for yes, there is light among the thunder.
Zachary, I sense Yom Kippur approaching in your poem also, I have to say. What is the relationship between this really evocative poem and the Supreme Court for you?
This poem is really, to me, about what's it like at this moment in our history where everything seems chaotic and in many ways depressing, and to see people trying to hold on to the last bit of power today in the Supreme Court, but all the time in different places, not actually trying to serve our ideals, but trying only to grab onto and hold on to the last bits of power.
That seems like the perfect spot to turn to Steve Vladeck here. Steve, the confirmation process as laid out by the founders was not supposed to be disorderly, as Zachary describes. It was supposed to be a very orderly process. Is that correct?
I mean, I think that's what they wanted. I'm not sure they did a lot to sort of guarantee that would be the case. I mean, the Constitution says nothing at all about the process besides that that it exists. The Senate shall provide its advice and consent. It doesn't say what that means. And, so I think, the founders, envisioned Senate confirmations as, usually fairly rapid affairs, either because it would be clear that the person should be confirmed, or be clear that they shouldn't be. And the history of Supreme Court nominations is actually rife with rejections. of candidates who were either deemed unqualified or too controversial or otherwise sort of didn't meet the bill. But the notion of the sort of hotly divisive confirmation hearing splayed out over national television, that's definitely more of a recent development.
Just going back to the founding moment again, what was their sense of what the qualifications would be, and what did they mean by advice and consent? You say that they were not clear, but we do have some sense of what they had in mind, right?
Yeah, I mean, I think they wanted obviously folks who were qualified in the Senate's view, and I mean, this is what's fascinating, Jeremy, as you know, the Constitution creates qualifications for office in the legislative branch. It creates qualifications for office in the executive branch. It creates no qualifications for judicial offices, including the Supreme Court, not because the founders didn't think that these judges should be qualified, but because they thought the Senate would do that work. That, if the president just so happened to nominate a 14-year-old Romanian gymnast to the Supreme Court, the Senate would have no trouble rejecting said nominee. So I think the idea was, we wanted folks who were qualified in the sense that they had a career that showed that they were, of the highest caliber in the profession, that they were able to dispense justice impartially and fairly. Again, keep in mind, the founders, didn't necessarily anticipate the rise of the modern party system. And so the notion that, confirmation battles would just devolve into, competitions for which side can get over 50 votes, how far to the extreme of your party can you go and still get 50 votes? I think that would have been very foreign to the founders.
Right. And as you say, they were not aware, or nor did they anticipate the party system as it soon developed. But of course, slavery was a paramount issue. And is it fair to say, as I think our colleague Sandy Levinson has argued, that built into the court system is a kind of innate conservatism, then a presumption that whoever's nominated would have to be acceptable to the most conservative elements in American society?
I mean, I think I wouldn't say the most conservative elements, Jeremy, but I think, yes, that having the Senate be in charge of the confirmation process, which of course was a matter of some debate at the Constitutional Convention, was either deliberately or at least consciously a reflection of the notion that, small states, which, including but not limited to slave states, would not get run over when it came to the confirmation process. That there really would be geographic division and geographic representation in the confirmation process, no matter how population patterns emerged. And frankly, I mean, the first Supreme Court nominee who's rejected is actually rejected on policy grounds. It's John Rutledge from South Carolina, who had been an associate justice on the first Supreme Court. And then he had left to go become the Chief Justice of South Carolina. He's Washington's first nominee to succeed John Jay as Chief Justice. And, he makes the incredibly dumb move of going out and speaking very, very aggressively, I think, against, if memory serves, the Jay Treaty.
Yes.
While his nomination was pending.
Right.
To which the Senate responds by promptly rejecting his confirmation as Chief Justice. So, the notion that political considerations are going to be part of this process dates back at least to the Rutledge confirmation. But, it's still not the same as what we see today, where you have, the parties lining up neatly in the camps, where, I mean, as we've seen with the nomination of Judge Amy Coney Barrett, where the Republicans have basically signaled, and indeed did basically signal that they were going to confirm whoever the president nominated before there was even a nominee. That's new.
Right. And so when would you date the beginning of this more partisan process? When do we see the parties lining up this way? And when do we see it becoming such a national political issue in the way it's become recently?
Well, I mean, I think the notion, the whole idea of confirmation hearings, I think, is part of this story, and that dates back to the early part of the 20th century, where there was this moment. I think it was Justice Brandeis, where the Senate actually wanted to ask some questions and have some process before he was confirmed in 1916. The same thing happens with Justice Black in 1937. And so we see the gradual rise of the confirmation hearing. But Jeremy, even then, I mean, a majority of the justices, or at least a majority of the nominated justices, are confirmed on voice votes all the way into the late 1960s. Justice Fortas was confirmed in 1965 on a voice vote. Imagine that today.
Right.
And even in the 1970s and 80s, you still see heavily one-sided votes. Antonin Scalia was confirmed 98-0. Right, Sandra Day O'Connor was confirmed 99-0. John Paul Stevens was confirmed 98-0. So I think it's the Robert Bork confirmation hearings and the defeat of Bork as a nominee in 1987, I think, were a flashpoint for this. I don't think it began with Bork, Jeremy, but I do think it accelerated and became much more of a sort of consistent theme to confirmation hearings, starting with Bork, Clarence Thomas, and especially in the last 10, 15 years.
And do you think that's because the court has become more important in the political lives of citizens?
I think that's part of it. I also think that the court has also become perceived in much more strictly partisan tones. Right? We had a long period of time where the political affiliation of the appointing president was not necessarily predictive of the justice's ideological commitments. We had, two Republican appointees, John Paul Stevens and David Souter, who formed, a big part of what was called the liberal bloc on the court. John Marshall Harlan, who today I think no one would think of as a conservative, right, was, an Eisenhower appointee. So I guess, Jeremy, part of it is that we are viewing the court in more partisan terms. Part of it is, I think, the court itself is feeding this narrative by handing down so many more decisions that break strictly along these kinds of partisan lines. And frankly, I think part of it is just, a symptom of the broader polarization of all of our politics, where it was just, inevitable that the Supreme Court would be part of that story.
Is it also that, and this is an argument I've heard many make, is it that the justices are now so vetted in such detail by presidents and their administrations that they're actually choosing people who are less likely to change their positions over time? You do point to David Souter as one who did this, but it's hard to see much movement in Clarence Thomas, for example, during his time on the court.
Yeah, another way of putting that same thing, Jeremy, which I agree with, is we're not appointing moderates anymore. And, this is where I think one of the many casualties of the Merrick Garland affair was that, whatever Mitch McConnell wants to say to the contrary, Garland's a moderate. That was, I think, a naive but olive branch by President Obama that, for Scalia's seat, he's not going to try to ram through a liberal, right? He actually wanted someone who was moderate. And of course, the Senate said, no, thank you. I think it is increasingly not in the president's interest to appoint anyone other than the most radical member of their party that they can get through the Senate. And that is as much about the Senate, I think, as it is about the president. If the reality were, if Trump knew that he could not get 50 votes for a radical conservative, if he knew he had to appoint someone much more moderate, then it's very possible that, we hear a very different name coming out of his mouth last Saturday afternoon. But, he knows that the one thing he can absolutely count on in the Republican Senate majority at the moment is, support for whoever he nominates. And so as opposed to, say, Harriet Miers, who President George Bush, nominated only to have killed by his own party in 2005, we knew going in that this was going to be someone pretty far to the right. Indeed, it's why a lot of people were able to predict that it would be Amy Coney Barrett.
Yeah, we've heard a lot lately about this idea of textualism or originalism. When did this idea sort of become like a calling card for conservative justices? And could you maybe give a brief summary of what textualism or originalism is?
Yeah, so, what the court, as Jeremy said, I think earlier, Zachary, right, the court has always been, with maybe a very small exception in the 1960s and late 50s, a small c conservative institution in the sense that it moves slowly. It tends not to be at the forefront of social change, tends to be responsive to broader shifts in public opinion and not ahead of them. The rise of what we might think of as the modern conservative legal movement, I think, really does begin as a sort of backlash against the perceived excesses of the Warren Court. And so there's a whole generation of lawyers, who go to law school in the 60s and 70s, who go to work in the Nixon and Ford administrations, and maybe even the Reagan administration, for whom, the court had become way too powerful, in sort of expanding individual rights and expanding the role of the courts, in limiting what states could do, in allowing Congress to do things Congress never been allowed to do before. And so this is the generation that produces Antonin Scalia. This is the generation that produces, Clarence Thomas and, Samuel Alito, and sort of right behind them, John Roberts. And I think it's very much it is not about conservatism in the sense that the court should stay out of these affairs. It's conservatism in the sense that the court's aggressiveness should be directed in other ways, that the court should actually be constraining the federal government when it comes to ordinary economic regulation and leaving more room for the states, that the court should be, doing more to recognize religious liberty as opposed to unenumerated rights. And I think that's, textualism and originalism are parts of that movement, but they don't describe the whole movement. That, originalism is one of the methodological approaches that we tend to associate with conservatives, but it's not the only one. Originalism actually doesn't describe or explain the entire conservative understanding of the Constitution, not even most of it. Ditto textualism, but they're all sort of swimming in the same direction, which is, at least superficially constraining the role of judges in many but not all cases.
So this brings, Steve, us to the question that I think as a historian always animates our analysis of these issues. To what extent are these arguments about originalism or activism and restraint, to what extent are they real arguments motivating what people do, or to what extent are they post hoc rationalizations for power moves? It seems very difficult to consistently find evidence that the confirmation process and then the jurisprudence of the judges follows some philosophy. It seems more obvious that it follows the desire for political power for particular groups.
I think this is the great debate. And one of the things that is maddening to me about the confirmation process is that to what little extent we actually end up having a public debate about these theories, the debates occur at such a superficial level as to be almost meaningless. So the originalism debate is pitched in terms that no one could disagree with, right? That, of course, what the founders actually wrote and what those words were understood to mean is at least somehow relevant in how we understand the Constitution. No one disagrees with that, right? The question is, when should it be dispositive? Jeremy, I think there really is a lot of evidence for the notion that at least plenty, not all, but plenty of these folks, use these methodologies the way that a drunk uses a lamppost, right? For support rather than illumination.
Yes.
The problem is that, that's, it's hard. First of all, it's hard to prove that. And second, to actually get into the weeds, to really explain the pitfalls with original public meaning as a touchstone of constitutional interpretation requires degrees of nuance that, obviously we aspire to in our law school classes, but that are just impossible for the public sphere. And so, the example I always love to use, is the excessive fines clause of the Eighth Amendment. So, most folks know the Eighth Amendment prohibits cruel and unusual punishments.
Right.
It also prohibits excessive fines. And that begs the question, of course, well, what makes a fine excessive?
Right.
If we are engaging in a purely static form of originalism, then just about every fine levied by government today is excessive, simply because of inflation.
Right.
Excuse me. To which, of course, everyone asks, well, no, excessive obviously has to be understood by at least some reference to, present day conditions. And once you concede that, you are giving up the ghost on most originalism, because you're saying at least some constitutional provisions are dynamic and have to be understood by reference to evolving understandings. And then it's just a fight over which provisions, fall into that category.
Right. And it also seems to me as a historian, and I think this is something Akil Reed Amar and other legal scholars have argued as well, the history that is often used to justify an originalist position is actually not very good history. So it's not clear they're actually getting at the originalism.
I mean, it's not very good history, Jeremy. At the very least, it is often debatable history, right? And so I think the term that the law professors have for it is law office history.
Yes.
Which is it's not a compliment to call someone a law office historian. And I think, I mean, another really good example of this is the nerdy but important topic of state sovereign immunity. That is to say, when can a non-consenting state be sued? Without just if they've done something wrong. And there was this huge renaissance and revolution in the Supreme Court's jurisprudence on this exact topic in the 1990s, spurred on by the conservatives and spurred on by at least putative invocations of originalism. But the historical materials are actually incredibly ambivalent on this. And so we have this problem where the sort of folks who say originalism is the only right way to interpret the Constitution just don't fully account for how much of the Constitution can't be satisfactorily their word is liquidated, but I would say fleshed out, right, solely based on even good history of the founding,
right?
Because the reality is the founders didn't think about everything.
They couldn't. There's no way they could. There's no way they. So coming back to the confirmation process, if we don't have a clear standard of what justices should be thinking. I mean, ostensibly, we have a standard of what are the skills and behavior patterns we want when we're appointing someone to be a tax collector or to play some other role like that, even to be a professor, right? The tenure process involves peer review. Do we do certain kinds of research? Have we met certain standards? If we don't have that for the appointment of judges, or if it's much murkier, how do we avoid falling into the trap it seems we've fallen into, where this is purely about power, where the Senate, the Republicans in control of the Senate under a Democratic president say, we're not going to let you replace Antonin Scalia. In fact, Amy Coney Barrett herself said that 4 years ago. And now when the same Republicans are in control of the Senate and you have a Republican president, they say, oh, well, now we're happy to go forward in an election year. How do we avoid being stuck in a place where it's purely about power? Or are we okay with that?
That's of course the really hard question. I'm not okay with it being purely about power, if only because it means you polarize the court, right? That insofar as our demographics are going to lead to cyclical shifts in who's in power in Washington, that's going to create a superficially balanced court, Jeremy, but a court with no middle. And I wrote a piece last year. One of the things that I admired about Justice Sandra Day O'Connor was that she really was a centrist in ways that Anthony Kennedy wasn't. Like we tend to think of Kennedy as being the swing vote and the median vote for the most of the last 12 years of his career, but he was the median vote, Jeremy, only in the sense that if you averaged out his votes, he was in the middle, right? He bounced wildly from one side to the other, and O'Connor was the opposite. O'Connor was always in the middle, and Evan Thomas has a wonderful book about O'Connor called First, which I think spends a lot of time unpacking how the influence she had, not just in what the court would hold in these cases, but in which cases they would take, in how they would even think about the issues, just by the fact that she took a more pragmatic, centrist approach to these cases, and what it means to a court that no longer has anyone like that. And I think it's whatever your politics, I think a court with no middle suffers from many of the same problems as a Congress with no middle, which is that there's no effort to build consensus. There's no reason to compromise. There's every reason to double down on tribalism. And I think the only way you can there are two ways to fix that. I mean, one way is a president who is willing to unilaterally disarm, which I think it's easy to understand why there's no incentive right now for that to happen. The other way is to actually not take it out of the president's hands, but at least put some kind of bipartisan commission into the mix, the way that a number of states do. So a number of states actually have judicial nominating commissions that are designed to actually identify really who are the creme de la creme, who are going to be the best judges on merit. And then, the relevant official, the governor, whoever, could pick one of the people who's sort of elevated by the nominating commission. That's a model we might want to think about. I mean, it has the small problem of being unconstitutional.
Right.
But maybe a president could at least soft commit to following recommendations of such a commission as opposed to being bound by them.
Is there a curious way, Steve, in which the filibuster sort of did that before it was eliminated for judicial appointments?
Well, yes and no. I mean, the problem with the filibuster is that it's not symmetrical, right? That the filibuster the filibuster in requiring a supermajority required even more from Democrats than it required from Republicans, because of the way population patterns are and the way representation works out in the Senate.
Right.
And so I think the problem is that, yes, it required that more than today, but still in ways that are asymmetrical and not necessarily consistent. I think the better approach, right, would be to think carefully about, sort of some kind of mutual deal where the median senators, right, like this was the idea behind the so-called Gang of 14 proposal back in the 2000s, where 7 senators from the left and 7 Democrats, 7 Republicans got together and said, the 14 of us can control the flow of judicial appointments because both sides need us. And we're going to agree on some basic principles, right, to guide those appointments. That's what has disappeared. That's what's missing from today, is anyone who's going to exert anything other than partisan, justifications and commitments and qualifications on the confirmation process. And I think that's unfortunate. Like, I think that really is a shame.
So just moving it to where we are right today, if Amy Coney Barrett gets confirmed, which it looks like she will.
I was going to say when.
Yeah, well, okay. Either right before the election or right after the election. What should, if there is a President Biden who follows this, what should he do?
I'm probably the worst person to ask that question of, because I am. How do I put this gently? I am a weird progressive in that I am a judicial supremacist progressive. My sort of gut reaction is Biden should do very little. That, I think there's a conversation to be had about court reforms in general, about ways of, sort of making the federal courts fairer and more egalitarian in what they do. I think there are personnel reforms with regard to sexual harassment in the judiciary that, of course, should be pursued. I think access to the courts would be a really powerful measure for the Democrats, where, it's so hard today to actually sue the government when they break the law. Making it easier, wholly apart from who the judges are, I think would be a positive step. I am not a fan, Jeremy, of the notion of, what do you want to call it, court packing or court unpacking or whatever.
Expanding the court.
However you want to call it. I think it's very, very short-sighted, because, to whatever extent Democrats are rightly angry about the hypocrisy of Republicans vis-a-vis what they said in 2016 versus today, about how everything went down with the Kavanaugh confirmation hearings. There's no denying the anger and the frustration. The problem is that if Democrats in 2021 add 2 seats to the Supreme Court, which Congress has the power to do, then the next time the Republicans are in power, they'll add 4. And the next time the Democrats are in power, they'll add 6. And in 15 or 20 years, we'll have a Supreme Court with 37 justices and no legitimacy. And so, I know there are folks who will see that as a feature and not a bug, but I guess I'm not one of them. And to me, the way to sort of push back at all of this is to make it clear to everyone why we need the courts, what we expect the courts to do. If you want to add judges, great, add judges to the lower courts. I mean, that's not nearly the same kind of, norm intruding behavior. But messing with the Supreme Court because for what will clearly be perceived as partisan reasons, I think is a very dangerous, road to go down.
So 2 other quick questions. What do you think about putting an 18-year term limit on justices on the court?
So I like the idea in the abstract. I actually do think there are ways to do it that would not be unconstitutional. That's usually the first objection you hear is that they get life tenure. There are ways to read Article 3 where, as long as you keep paying the judges and as long as they have something to do after 18 years, it's not violating Article 3. I'm not worried about the constitutional objections. I'm not sure that would actually, solve this problem. Like, so a confirmation every 2 years adds a degree of predictability to the process, right? It reduces the odds that we're going to have the sort of unpredicted, Scalia death, unpredicted Ginsburg death coming when they did. But I don't know why the appointments wouldn't be just as political even if they were predictable. I don't know why presidents would be inclined to sort of moderate themselves at all in that context versus actually having a license to be even more aggressive and perhaps even more extreme. I don't love the idea of justices who might be looking for jobs. Right? If Amy Coney Barrett served an 18-year term, she'd be 65 when she left the court.
Right.
That creates pressures that I'm not wild about. There's a whole history of why Congress finally broke down and gave the justices good pensions. Right, because of all the awkward incentives that the lack of a good pension was creating.
Sure.
So I don't mind the 18-year proposal. I just think that there are other ways that we ought to be thinking about, the role of the courts in our system. If we think the court is hearing too many of these high-profile, politically divisive cases, Congress has a lot to say about the court's docket. Right? I mean, Congress over much of the 20th century gave the Supreme Court a lot more control over its docket, culminating in 1988, where, since 88, almost every single case the Supreme Court gets to choose whether to hear or not. Why not go back on that? Why not, actually start picking again more aggressively which cases the court has to hear, and maybe even finding some cases we think the court shouldn't hear? I mean, I think, those are the kinds of conversations I think we ought to be having about court reform, as opposed to just, thinking that we can somehow take the politics out of the confirmation process, either by adding seats or by imposing term limits.
This is really helpful and very thoughtful. So the final question I wanted to ask you then is about the current predicament. There's no doubt that what we're going through right now does to some extent delegitimize the court, right? If the perception is supposed to be that you're getting impartial justice, and the process of getting on the court, no matter whose fault it is so highly politicized that certainly takes away the veneer of impartiality. It can be recovered, but it does take away the veneer of that to some extent. What happens if, God forbid, the election does somehow go to the Supreme Court, which it won't necessarily and probably shouldn't? How do you think the confirmation process affects that, and how do you think the nominee affects the role of the court? You mentioned Sandra Day O'Connor before. She will always be remembered, and I think she regrets, right, her role in Bush v. Gore, the 2000 decision that actually gave the election to George W. Bush. So how do we think about that moment, and how do we think about this moment today with this confirmation and this bitterly fought election coming up in 30 some odd days?
So, I mean, I think there's no question that the Supreme Court is in a much more fragile position today than it was in, at the same moment in 2000. And that, so just off the top, I actually think it's going to be very hard to see a repeat of Bush versus Gore, because this is a very different court today. Yes, it's more conservative, but it's also a court that I think is well aware of just how fragile things are at the moment. I mean, this is a court that I think is, 2 or 3 steps away from, really, really provoking legitimacy concerns among a majority of the population. I mean, there's already a good chunk of the population thinks it's illegitimate, but so I actually, I actually think if we do see an election-related dispute that gets to the court, I expect them to actually be very wary of leaning in heavily in favor of the president. And indeed, I actually think if it gets down to a Bush versus Gore-like scenario specifically, it wouldn't surprise me at all if, a confirmed Justice Amy Coney Barrett recused herself. For 2 reasons, right, Jeremy? I mean, the first is, the first is sort of practical and a bit cynical, which is if the long-term conservative project is judicial hegemony, a court with no legitimacy is antithetical to that project. And, sort of taking steps that are going to really, really undermine the public perception of the court in an electoral context, I think could actually be far more dangerous today than it was in 2000. Keep in mind, Jeremy, in 2000, it wasn't an incumbent who had appointed 3 of the justices, right? Who for whom the court swung the election. The longer term piece of this is I also think that if you are John Roberts and who's one of the smartest guys around and who really does have really does take the long view. I mean, one of my favorite John Roberts stories is when he called Elena Kagan right after Kagan was confirmed by the Senate and said, "Congratulations, I'm really looking forward to working with you for the next 25 years." And Kagan snaps back, only 25.
Right.
So, if you're John Roberts, one of the best things you could do is rule against Trump in an election-related dispute, because that's going to do so much to sort of quiet at least some of the legitimacy objections and at least some of the hostility. And it's going to create so much room for Roberts to actually do all kinds of bad stuff on the merits in the future. So I mean, maybe this is naive, but I actually think, the specter of the new conservative majority, icing the skids for Trump in the election is really, really, really unlikely, if for no other reason than because it is in so many ways going to be against the court's interest to do that.
That's very reassuring to hear, and it makes sense, and I believe that myself. On the other hand, I just can't imagine this did not come up in President Trump's discussions with Amy Coney Barrett.
I think that's right, but I don't. I mean, one of the questions I really hope she's asked at the very brief confirmation hearings to which she's going to be subjected is whether there were any discussions about election-related cases and whether she was asked about whether she would recuse in any of these cases. I would like that to be on the record, but I think it's worth stressing though. I mean, it takes it's not just about Amy Coney Barrett at this point. Like you need 5 votes to win one of these cases. And, with the Chief Justice, and, this may sound surprising, but I think to some degree, someone like Justice Kavanaugh, I really think that they're going to be more interested in protecting the court's power in the long term, especially now that they have such a solid majority to, expand the Second Amendment, to reinvigorate religious liberty, to push back against Roe, to do all kinds of really, really, to me, problematic things. I think the last thing they'd want to do is spend all of their power, in an election dispute that's going to, potentially lead to the reelection of Trump and to the demise of the Supreme Court as a well-regarded institution.
Interesting. So there's a distinction you're drawing, which I think is very persuasive, between short-term partisanship and long-term partisanship.
I think that's right. And, and I mean, for better or for worse, when you have a Supreme Court with what are, at least for the moment, effectively lifetime appointments, we should expect the justices to be much more focused on the long-term politics and playing the long game. And, I don't know if that's a good thing in the abstract or a bad thing. I think in this moment in time, it's probably a good thing, at least as we look ahead to the next 6 weeks.
That's very helpful. Zachary, when I was your age, and I think Steve's about the same age as I am, so when Steve and I were your age, we were taught, I'm sure Steve was taught this as well in high school, that the Supreme Court was the place that solved problems, that issues that couldn't be solved in the legislative process often went to the court, and the great Earl Warren Court and other courts under Warren Burger as well was a place where these things were finally settled by wise men who deliberated over these issues. Obviously, it's a very different world today, as your poem pointed out. How do you and your generation, when you think about these issues, I know you're thinking about them a lot right now, how do you view the court, and what do you see as the future of the Supreme Court within our democracy?
I'm not overly cynical about the future of the court, but I do think that my generation as a whole is very cynical about American politics in general, but in particular the Supreme Court. I think the Supreme Court is seen in many ways as an extension of politics, and I'm very interested to see in the next few years and even the next few decades if the Supreme Court will be able to gain back some of that legitimacy, and maybe because of that perception they will be forced to make decisions that are more in line with the views of young people. But I'm very wary of anyone who would claim that the Supreme Court has supreme legitimacy across the board among the American population, because I think young people are really doubtful of its nonpartisanship.
I think that's very insightful, Zachary. Steve, thank you for your insights today. I think you've given us a really good sense of how the legitimacy of the court evolves and what the real crisis of legitimacy is today, and how the confirmation process is part of that, and how we could see ourselves maybe moving out of it in the future. Thank you for joining us, Steve.
Of course. Thanks for having me.
And Zachary, thank you for your poem and your insights. And most of all, thank you to our listeners. Please remember to vote. And if you live in Texas, please remember that you must register to vote within the next week. You must be registered 1 month before Election Day. And if you live in other states, please make sure you check on your registration requirements and whatever voting by mail requirements you have as well. We look forward to hearing from you and speaking with you again on This Is Democracy.
This podcast is produced by the Liberal Arts Development Studio and the College of Liberal Arts at the University of Texas at Austin.
The music in this episode was written and recorded by Harrison Lemke, and you can find his music at harrisonlemke.com.
Subscribe and stay tuned for a new episode every Thursday featuring new perspectives on democracy.